Hello, my name is Mick O'Hara. I'm a district court judge in the 14th Judicial District. My topic is motions to continue. From time to time, judges will be presented with motions to continue in criminal proceedings. There are many different options on how to handle motions to continue, and we hope to offer you an outline to assist you in your determination of such motions. The good news is that it is generally discretionary whether the court grants a motion to continue or not. However, as usual, there are pitfalls to avoid. It is crucially important to remember that an accused person in a criminal case has the right to a speedy trial that must commence within certain deadlines, and of course, there are certain exceptions. You can see generally Colorado Revised Statute 18-1-405. While there are several bases for tolling this right listed in the statute, a violation of this provision will generally require dismissal of all charges. While some case law supports concluding that speedy trial rights can be waived by implication, it is probably a better practice for a judge to always consider obtaining a formal waiver of the right to a speedy trial when granting a continuance in any case where the trial date might be impacted. There are several factors which may be considered when ruling on a motion to continue. A summary of these factors has been suggested by our Supreme Court in People v. Brown at 322 Pacific 3rd, 214. In that case, a defendant requested a continuance of the trial to hire counsel of his choosing and discharge his court-appointed counsel on the day of trial. Still, many of these factors will assist judges in evaluating any motion to continue. Did the party filing the motion cause the problem? The length of the requested continuance? Any prejudice to either party beyond mere inconvenience? Will witnesses be unreasonably inconvenienced? The age of the case, from both the offense date and the filing date. Has the case been continued before? The timing of the motion. The impact on the court's docket. The victim's position, if the Victim Rights Amendment applies. And any other case-specific factors necessitating or weighing against the continuance. Like many of the things we are asked to do, a good rule of thumb is to ask whether the request is fair, balancing all of those factors. In asking that question, a judge will have to determine whether either party will be prejudiced if the motion is granted or denied. The court will also have to consider the amount of prejudice that might result from the court's ruling. Because every motion to continue will be specific to the facts and circumstances of each case, the trick is finding a balance that is fair to both parties. Remember to always make findings of fact and conclusions of law to support your ruling.